SJC-12780, Susan Boss, v. Town of Leverett.
Ms. Crowley, good morning.
Good morning. If it please the court, my name is Rosemary Crowley. I represent the town of Leverett in this appeal. Just to orient us, Leverett is a small town in western Mass. It has a population of approximately 1,800 people. It is located east of the Connecticut, west of the Quabbin, and north of Amherst, south of Vermont.
It's south of Vermont. Okay. Help us decide the case then. Go ahead.
And this may also help to
South of Canada, too?
Yes. Your Honors, this is a somewhat straightforward case. A ballot question was placed before the citizen legislature of the town of Leverett. That ballot question, which is prescribed by statute, states, shall the town, by state statute states, shall the town pay half the premium cost payable by a retired employee for health insurance? And
Does it quote the statute?
excuse me?
It quotes the statute?
Yes, Your Honor, I have in its entirety, it says, shall the town pay half the premium cost payable by a retired employee for group life insurance and for group general or blanket hospital, surgical, medical, dental, and other health insurance.
Is that the way all the ballot questions typically read in towns that have adopted the statute?
This ballot question is set forth in Chapter 32B, Section 9A. It is the ballot question that the state calls for all towns to place before the,
Okay, so I don't mean to interrupt you, but I just need to bring it to my bottom line is it's just it's the same for everybody and everybody.
It's the same for everybody, Your Honor, for all towns.
Okay, that's right. So there was nothing unique about the way that Leverett did it.
There is nothing unique except that Leverett is a town under town meeting government.
Right.
And so, unlike, it's not uniform for all 351 municipalities in the Commonwealth, but for all with town meeting structure.
Okay.
Was there any discussion about what this would mean for the town before it was put to the town meeting?
Significantly, Your Honor, there was, within the warrant posted for the town meeting, there was Article 2. Article 2 provided for an appropriation to correspond with the provision, with the adoption of this 9A. That is set forth in the materials. It is located in our brief at page 8. And the significance of Article 2, which was simply an appropriation article, first of all, it was contingent upon passage of the ballot question.
But I guess my question is more about whether there was a discussion about whether it would mean the premium paid or the individual premium due.
Yes,
by
Your
a
Honor.
retiree, yes.
Specifically in the text provided, the written word put before all the citizenry of Leverett through a newspaper posting as required by Chapter 39, Section 10, the Article 2 stated in describing what the appropriation would be, and I'm giving it to you in relevant part, the town will pay 50% of the cost of an individual health plan offered by the town for a retiree as long as the retiree, et cetera, et cetera. So the Article 2, which tied itself to the ballot question, specifically indicates to the citizenry legislature that they are signing up if they adopt this, if they vote affirmatively on the ballot question, then they will be signing up to pay for 50% of the retirees' premiums, the premiums attributable to the retirees' costs.
But that's the only indication that that's what somebody thinks it means. There was no...
No, Your Honor. I would say the most significant piece of evidence in this case came through the decision of the Superior Court judge, where the Superior Court judge found that the ballot question itself did not include the word dependents, and therefore the ballot question itself was ambiguous. That is a, yes, Your Honor.
Please finish your, I didn't mean to interrupt. Please finish your answer.
Where I think that the lower court misstepped was that the lower court applied the inappropriate policy in determining which way to go, given the ambiguity.
So the ambiguity is really in the statute, right? You're saying the statute, it's not just in the ballot question, it's in the statute itself.
He is talking
No, I
about
mean, your position is that it's in the statute itself, not just in the ballot
in
question.
both the statute and the ballot question.
Because the ballot question just reflects the statute.
Yes, yes, Your Honor.
Okay.
Isn't your bottom line that Section 9A doesn't have the word dependent?
The bottom line is that, yes, the word dependent is not in there, and also, too, that a Superior Court judge found this language to be ambiguous, language that was put before a citizen town legislature. And so, therefore, you know, if you find that the language in the first instance, the word dependent is not included, where it is included in similar ballot questions, where 32B is asking a town, or is giving the option to a town to take on a financial burden and provide a significant benefit to their employees, the legislature in other ballot questions has been very careful to include the word dependent. And in this particular section, 9A, the word dependent is not included. And, Your Honor, the speculation is that, I believe that the lower court speculation was that the reason it was not included was because perhaps it was redundant. Your Honor, I would only state that it is equally credible speculation that the legislature omitted the words dependent because it wanted to provide a shorter step to extending benefits to employees.
What do you mean by a shorter step?
Sure. Okay, with respect to, as we all know, the town is under no obligation to contribute at all to the premiums of retired employees, and this is something that the town takes on voluntarily. So when 32B is first enacted, the retired employee is responsible for the full premium. Then, like an a la carte menu, there are various local option statutes which the towns can adopt to increase the financial burden on themselves, but extend a further benefit to their employees.
In this case, though, the employee benefited by having a family policy, right?
Well, that is another area where the two policy goals of the Chapter 32B need to be carefully separated. Under Section 1 of Chapter 32B, the enunciated policy goal is to provide a plan to municipal employees, okay? And that means the access to plan coverage. There is no, that statement is devoid of, Section 1 is devoid of any statement that the policy goal of 32B is for towns to pay for those policies. It does, Section 7 provides automatic 50% contribution to active employees, and Section 9 provides that the retired employee shall pay in full.
Now, Section 1,
Yes.
the purpose of this chapter is to provide a plan of group life insurance and other types of insurance for certain persons in the service of counties, cities, towns, and districts, and their dependents.
Correct.
Purpose speaks specifically about employees and their dependents.
It speaks, yes, Your Honor, in terms of providing access to group insurance plans. And there's extensive discussion in the various case law cited where they talk about access to coverage. And it is you have to be very careful to separate out access, the benefit of being allowed to purchase, the group purchase of insurance lowers your premiums. And that is what the legislature, the state legislature, was trying to encourage was municipalities use your power of, power in numbers of purchasing these plans. So Section 1 only speaks to give them access to plan
Then
coverage.
you have Section 9A, which is last amended in 1959, correct?
I believe it was, I apologize, Your Honor, for some reason I believe it's 1965.
Okay, well, in 1966, well, at the time, it was, whether it be 59 or 65, Section 9 at that time said that spoke of the entire premium for, quote, for such employee and his dependents. So that language was in Section 9 at the time that Section 9A was last amended.
Okay.
And then that language was dropped to cut out for such employee and his dependents in 1966. So how do you say that Section 9A, when it was enacted, was not understood to include the employee and his or her dependents?
Because if you read the ballot question that is put before the citizenry legislature and you compare it to the other statutes, the word dependent is excluded. And so therefore, the citizenry legislature has a right to take the plain meaning of the statute. So, you may be able to narrow the question.
You say it's the plain meaning of the statute, but
The plain meaning
if you're
of
an
the ballot
employee and you pay, the question, I believe, is, shall the town pay 1/2 the premium cost payable by a retired employee for group life insurance and for group general or blanket hospital, surgical, medical, dental, and other health insurance, correct?
Correct.
And the employee pays for his or her own policy, but would also pay for the family policy.
Your Honor, the language of the ballot question being the unique to towns, does not say that.
Well, it just says payable by a retired employee. But certainly, so you're saying that we should interpret that the legislature meant this to be to pay the cost payable by a retired employee for him or her alone, and not for any dependents? You think that's what the legislature intended, even though it was focused on providing coverage for the employee and his or her dependents?
I believe in the language of 9A, I believe the language of 9A, at best, if you want to argue coverage for the family plan, at best, the language set out in 9A is ambiguous.
Okay, so what do we do? I mean, yes, it's plainly ambiguous, that's why you're here.
Yes.
But what do we do with that? I mean, many towns have enacted it, and if you're right, all those towns now will say, well, actually, we now will only pay for the individual premium because that's what the SJC says this statute means.
Yes, and
So all the people who now are receiving, for all of those towns and such which approve 9A, now will be able to go back to their retired employees and say, turns out that we were wrong, the SJC says that this applies only for individual policies, and therefore you need to pay us back the difference between the individual policy and the family policy? Is that what will be the consequence of you winning today?
Should we win today, first of all, Your Honor, you have nothing before you, regarding how other towns are doing this. This was enacted.
Language is required by the statute, so clearly every town which enacts 9A has to ask this precise question.
And Leverett, for years, has been interpreting it as only covering half of the premium attributable to the coverage
But
for.
either you're right or you're wrong. I mean, each town can interpret it its own way.
Right, correct, Your Honor, but the that is why we are here today, and the impact of how towns have been interpreting this is irrelevant, because some towns have been interpreting it one way, and perhaps we have evidence that Leverett has been interpreting it and administering it in this way. There are likely other towns who are doing it as well. And so therefore, Your Honor, I would ask that the safe course of action here is to restrict the interpretation to only covering 1/2 of the premium attributable to the insurance coverage for the individual retired employee. It was the baby step intended by the legislature, and with that, I will conclude my remarks.
Okay, so
Can
let
I
me,
ask another question
Yes, sure, go
if
ahead.
you're done? Which is that, you say that there's this ambiguity, and of course, we all agree with you. Do we not read the purpose of the chapter then as part of what is going to help us in terms of legislative intent? And because the purpose of the chapter is to provide for certain persons in the service of counties and their dependents. And then so we know that the legislature wanted these dependents covered, at least for the active employees.
Your Honor, and here's where the policy differences are very important. One policy is that all these the a la carte local options available, the policy to apply there for the legislative intent is to allow communities to control their financial well-being, and that one of the cases even states they are not permitted to adopt statutes they can't afford. So that is the policy that is relevant in interpreting this ballot question and this 9A. The policy of providing access to plans, that is what's stated in Section 1. And there is a big difference.
The purpose of the chapter is to provide a plan
So in this
in the service of counties.
case, I apologize.
I'm just finishing the sentence, so go ahead.
I apologize.
No, don't worry about it.
In this case, in this specific case, Ms. Boss's husband never lost coverage. He never lost coverage. What happened was the payment, the contribution to the premium was increased upon retirement. By adopting 9A, Leverett said, rather than having the retired employee pay the full boat, we're going to increase, we're going to increase our contribution. We are going to pay half of what is attributable to the retiree. And that's completely consistent with the language of 9A.
Counsel, one more question before we let you go, is in that, if the chief indulges me with this. Section 9D talks about a town voting to pay this premium of a surviving spouse.
Correct.
Why would that have to exist, that section, if Section 9A didn't contemplate a spouse being covered?
Because a town may elect to offer a contribution to the premium of a spouse whose spouse has deceased. And so that is a financial burden that the Section D, that the town can take on.
So you don't read anything into the existence of that statute in relation to 9A?
I believe that is completely consistent with the town's interpretation of 9A.
Chief, may I ask one additional? Thank you. It actually goes back to the Chief Justice's question. I'm not sure you completely answered it, because the statutory interpretation question you answered by referring back to the warrant at the town meeting. But the question, as I understood from the chief, was that, so we're assuming that 9A doesn't include dependents, because the word dependents does not appear in 9A. But when 9A was drafted, Section 9 included dependents, and that, I think, was the thrust of the question. I'm not sure you haven't answered that as it relates to statutory interpretation, separate and distinct from what happened at your town's town meeting.
Okay. Well, Your Honor, I believe that, I'm struggling, excuse me, Your Honor.
Sure, let me restate the question then.
Absolutely, please.
Let me just restate the
Sure.
question. So Section 9A, you look at 9A, and it doesn't have the word dependents. Well,
Correct.
that's pretty darn important.
Yes,
But when 9A was drafted,
yes.
Section 9 already had dependents in it. Shouldn't we assume, as a matter of statutory interpretation, that 9A with is the option of actually contributing part of a premium as opposed to 9, assumed that dependents were included within 9A if a municipality decided to include a premium payment of 50% for employees?
Yes. All right, so Section 9 is the default provision. When you adopt 32B,
understand.
you get Section 9.
I understand.
Section 9 says you will provide, and I'm not quoting, paraphrasing, Section 9 provides for the provision of coverage to the retired employee and their dependents. The provision of coverage and the provision and the payment of a premium are two very, very different things.
Completely understand.
Okay.
I understand your reference to Section 1 and access. But when 9A was drafted, the chief's point was, well, we're assuming in your argument that dependence is not included within 9A when the municipality decides to make a contribution. But
Yes.
when 9A was drafted, the access provision included dependents. So why isn't that important as a matter of statutory interpretation?
Your Honor, to me, it goes to the heart of the confusion in the case, which is coverage versus payment for the coverage. And 9A is a provision that provides for payment of the coverage, and 9A says nothing about dependents.
Okay, thank you.
Thank you very much.
Mr. Dunn.
Thank you, Chief Justice. May it please the court, I'm Ryan Dunn. I'm staff counsel for the Massachusetts Teachers Association. I'm pleased to address the court today on behalf of Susan Boss, a longtime teacher in Leverett Public Schools. Ms. Boss is in the courtroom with us today. I want to start off by addressing, if I may, just one thing my sister counsel mentioned with respect to the application of Section 9A as it exists in Leverett, and I want to address this right off the top because I think it is important. I heard my sister counsel say, and I hope I'm getting this right, that the town of Leverett has interpreted Section 9A in a way that the liability that the town has for a contribution to the retired subscriber's health insurance premium to 1/2 of the individual plan. And if the retired subscriber elects the family coverage, or in this particular instance, the 1+1 coverage, which is simply a variety or a flavor of family coverage, that only that 1/2 of the individual premium will apply, and the subscriber will be liable for the remainder of the premium. I actually don't believe that the town of Leverett interprets the statute in that way, and the reason I say that is if we look at Article 2 of the 2004 town meeting warrant, that warrant, and it appears in the record appendix at page 37. That warrant purports, I apologize, but the warrant purports to import this interpretation or import this limitation or restriction on the town's liability. And so that's not an interpretation of Section 9A. It is an effort or enterprise to limit or restrict the meaning and the reach of 9A.
Is the warrant the notice to the town, or is it voted on? Article 2 voted on, or is only Article 4, the legislatively required language, voted on?
So as I understand it, and I will give warning that I'm a union lawyer, not a municipal lawyer.
I probably should have asked your sister that, but go
But
ahead.
my understanding in this particular instance in particular is some acts of town meeting are accomplished by essentially a voice vote or a raising of hands, as I understand it. Whereas Article 4 of the warrant that's at hand was passed by means of a ballot.
Well, Article 4 has to be passed by, the statute requires you to pass Article 4, right? Article 2 was the town's embellishment on 4. I'm just trying to figure out whether it was even voted on, as opposed to the notice that went out to the town that this is what is going to be voted on or presented to the town.
Yes, Your Honor, and I would say that your characterization, I would subscribe to, that Article 2 is an embellishment upon the clear statutory language of Section 9 as it appears verbatim in Article 4. My understanding, and
This is all, the only reason this would matter at all is whether you have to do a redo of this, right? Because what the town voted can't change what the statute requires.
That's absolutely true, Your Honor.
Okay. Go ahead.
And I would go a step further and point out that adoption of Chapter 32B by means of accepting Section 10 of the statute and adoption of Section 9A, one of the local option features of Chapter 32B, those are irrevocable acts of the town legislative body. That's one of the issues at hand here.
What happens if you did it, it's irrevocable even if you did it wrong? I mean, Article 2, I agree with you, is, you know, it's different from what the legislature required, certainly, and it may be, but say we agree with your statutory interpretation, that dependents are included, but the town voted this in this inaccurate way, in misleading way, why shouldn't they have to redo it?
Well, I think that this court addressed that very issue in the Galensky case. And that case has, I think, important application to both of the issues raised by this appeal. In the Galensky case, what this court did is it said, Town of Irving, you have attempted to pass and enforce an unlawful restriction or limitation on the application and scope of Chapter 32B. In that particular case, the town attempted to import a tenure of service requirement before a retired employee became eligible to subscribe through the town's plans. This court said that's an unlawful limitation or restriction upon Chapter 32B, so you don't get to enforce that. In this specific case, it's actually even simpler in the way that town meeting acted. Article 4, as I said earlier, repeats verbatim the acceptance language of Section 9A. And that act is irrevocable. There's no way that town meeting the town can undo that. I believe that the town is asking this court to accomplish that same thing, and I would encourage you not to do that. And one of the interesting features of the way in which the town of Leverett acted here is Article 2 is a separate part of the warrant, and that should be deemed unenforceable in the respects that are material to this case, which is to say, this court should say, similar to what it did in the Galensky case, Town of Leverett, you may not enforce this aspect of Article 2 that purports to limit the town's liability for 1/2 of the premium cost for that subscriber. Interestingly, the town also purported to impose a tenure of service restriction very similar to what was at bar in the Galensky case. For what it's worth, I would submit that that's unenforceable and illegal
A
as
10-year,
well.
a 10-year tenure requirement seems different than, oh my goodness, we thought we were just voting for 50% for retirees. And we got a municipality, I think I heard of 1,800 people. If your interpretation of 9A is right, why isn't Justice Kafka right that the way to address it is to see what the town actually meant to do, rather than leave them with something that they may not be able to afford, that's going to not just hurt the dependents, but hurt the retirees if it can't be funded?
Yeah, I'm very happy that you asked that question, because I think it is very important to the case. On the one hand, I will say, I think when the legislature enacted Section 9A, it deemed that this 1/2 premium contribution by municipalities is a cost that can and may be borne by towns if the relevant legislative body chooses to do so. I would also point out in part that this is a very small town, and as a result, it has a pretty small base of public employees. And I think that there's a fair inference from the record that this was passed in 2004. However, it never came up until Ms. Boss retired in 2015. So you'll see that there are not a great many retired employees of the town. And in part, the answer is also, what we're talking about here is the incremental cost between 1/2 of an individual subscriber's premium and 1/2 of a family subscriber's premium. So it's not as if you're talking about the difference between the whole premium cost, similar under Section 9A, versus 1/2 of the premium cost. It's actually just that increment that's at stake. But I think there's also just the underlying question of what did the legislature intend when it acted this, and that's why we've been discussing Section 1 of the statute today, which very clearly says that the statute concerns employees and their dependents. And when you get to Section 9, and I believe my sister counsel made a reference to, I want to get the word correctly, provision of health insurance access under Section 9. But what Section 9 actually says is that coverage continues. And I think that usage of the word continues is critical in this case. In particular, you're talking about this distinction that underlies the appellant's case between individual coverage and family coverage. But in fact, the statute, in particular, the parts of the statute that are relevant to this appeal, don't make that distinction between individual coverage and family coverage. They just reference plans. And so Section 9 says that coverage shall continue for a retiree. That means that the coverage that you had when you were an active employee continues when you're a retired employee without any disruption to continuity. And I think that that's the real, that's what's absent from the town's case here, is they rely on this distinction between types of coverages, i.e. individual versus family, whereas the statute doesn't rely on that distinction. What the statute says is coverage continues for retired subscribers. And Section 9A, for purposes of scope or breadth, for what it's worth, only references the premium payable by the subscriber under the first sentence of Section 9. So the first sentence of Section 9 just, says the subscriber shall be responsible for 100% of the premium cost. And what 9A does is it reduces that liability to the subscriber to 50% of the premium cost, without any distinction between what coverage election has been made. And under Section 9, the coverage election just continues, typically, from the time you're an active employee to the time that you're a retired employee.
Well, then why do you need surviving spouse added to 9D?
Well, my understanding and reading of Section 9D is that, in essence, it converts the surviving spouse into the subscriber. And I think the structure of the statute demands that. If you look back at Section 1, if you look at Section 7 and Section 9, there is this qualification, I guess, or distinction between the subscriber and his dependents. And so in order to access a health insurance plan, there must be a subscriber, right? And I think what 9D accomplishes, in my mind, is converting the surviving spouse into the subscriber.
Can I return you to Galinsky for a second? Because I just read Galinsky. That's a much easier case than this one. They passed the statute, the town passed the statute, then it passed a separate rule years later limiting the statute. We don't have that. We have the town passing the statute based on potentially a misreading of the statute. Are there any cases like that that said that if a town does this wrong, the town's confused on what they're voting on, that it still goes into effect?
Well, the council certainly relied on a number of cases that concern a mistake or a misadventure, I suppose, by the public legislative body.
I'm just trying to figure out why, if you're right, but they put the wrong information into the warrant and the vote, why we don't make them do it over again?
I think, Your Honor, the best answer I have to that question is a voter at that town meeting may have very well imagined that they would pass Article 4, but not pass Article 2. We don't have any evidence in the record.
We know, did they vote on both?
That's my understanding, yes. The record is relatively thin with respect to what happened at that town meeting.
So it sounds like they voted on something that arguably the more detailed information may be, in your view, completely wrong. But the town would have voted on this with a misunderstanding.
I think, Article 4 of the town warrant, in my mind, is very clear and unambiguous. It adopts the statute verbatim, the acceptance language of Section 9A. And Article 2, you'll note from the language of the warrant itself, says that this is contingent upon passage of Article 4. So Article 4 is the, I suppose, executive function, if you will. And Article 2, being made expressly contingent upon passage of Article 4, implies that Article 2 may or may not be passed. But I would suggest that the underlying thrust of Galinsky is that if a legislative body has an intent or purpose of unlawfully limiting or restricting the scope or effect of Chapter 32B, then the correct action is to say that restriction or that limitation is unlawful and may not be enforced. Whereas Article 4, as passed by the town, shouldn't be touched
Okay, thank you. Before we go, with regard to the issue of whether the town meeting passed Article 2, we'll ask for a 16L letter on that. I saw Ms. Crowley's face with regard to the answer, so I assume the answer is it was, town meeting did indeed pass, but you'll tell us in a letter with whatever legislative history or the equivalent of legislative history will bear on that issue. Okay?
If I can try to be helpful on that point, with respect to Article 2, if you examine the pages 37 to 39 of the record appendix in detail, it does purport to note that a motion carried with respect to Article 2 for purposes of passage. And
Okay, well, why don't you get together with your sister and just send us something so that we don't need to be purporting we need to know, okay? So you'll just clarify that to the extent, I don't know whether it'll bear on our decision, but we should at least know the answer to that, so.
thank you, Mr. Chief
Thank you.
Justice. Thank you, Your Honors.